Now, back to the IR changes proposed by Christian Porter and the government. We heard earlier from the Australian Industry Group. We've heard also now from the unions. I caught up with the ACTU Secretary Sally McManus. Secretary of the ACTU, Sally McManus, thanks very much for your time. There's been a lot of discussion about a cooperative relationship between yourself and the Minister and the government in recent months. That seems to have gone today. What's your key problem with this bill as proposed?
Well, we're always prepared to work together so long as we made sure that no worker was going to be worse off. And we've said that from the beginning of this process. We said it during those 150 hours. And actually, we thought the employers and the government agreed with those ground rules. The thing we've got, the big problem we've got is that what's come forward leaves workers worse off in several ways. And so that's why we're concerned about it, and that's also why we're going to campaign to try and stop it.
The Better Off Overall test says that if the impact of coronavirus on an enterprise to which the agreement relates, then that can be, well, basically a business can provide an enterprise bargaining agreement underneath that Better Off Overall test for 2 years. If a business has been hard hit by COVID, why shouldn't they have that opportunity?
Well, for these reasons. At the moment, the law says that an employer can go and ask for that in exceptional circumstances. What this does is give the employers a whole lot more circumstances, including if they've been affected by COVID. Now, everyone's been affected by COVID. Everyone's been hard hit. If one employer in an industry goes and says, listen, we think we're going to go broke, we need to go below what the minimums are, it puts pressure on every other employer to do the same because they're competing with them. So we would say the minimum set of conditions, pay that workers have in this country needs to be the rules of business. And if you start allowing people to go below that, you basically push wages down for everyone.
In terms of that other provision you spoke of, the exceptional circumstances, that's what Labor put in place. The government, via the Minister today, is basically saying it's the same sort of provision. But these are exceptional circumstances.
It's not. Exceptional circumstances is already in the law, and employers could already, pursue that. It's a fairly high test. What they're doing is opening it up and lowering the bar, so allowing a lot more employers to go and argue this. And so, if it was just exceptional circumstances, we wouldn't be arguing here today.
The Minister said that. He in fact said that some of your comments, you're guilty of overstatement today. What do you say in response to that? Given what has been, as I say, a fairly cooperative relationship to this point, has that basically crumbled in the face of this
like
bill?
I said, this particular provision was a surprise to us. It wasn't discussed in those 150 hours. If it were discussed, we would have pointed out to him all of these points that inevitably employers will use COVID to say it's a reason why they've got to reduce things. That's a bad thing to do because this will be the outcome. But we never had a chance to put those arguments.
Because it's too broad is essentially
far too broad. Far too broad.
Is there a way to fix it?
Yeah, just don't change it. Leave it as it is now. Actually, no employer has even tried to use the exceptional circumstances. It's not as if they've even tested it and been knocked back for unreasonable, they don't really have an argument, and this argument's never ever been put during the working groups.
So this provision, the exceptional circumstances, as far as you're aware, has never been used, is that right?
Yeah, not during COVID. It's never been used.
But it's been used previously?
I'm pretty sure it has been used previously.
So some businesses have in the past, if they're going to hit the wall, basically say, we have to pay you less than the award, essentially. And
usually they do things like saying it's a temporary measure, for example. There's nothing in here about temporary measures. It could go on forever, these changes. We've still got work choices agreements that went less than the award, and it's 13 years after work choices. So, these are all just basic things that we would know are problems with proposed laws, but we didn't get a chance to put those arguments.
You said it goes on forever, but isn't there a 2-year expiry date on the agreements?
So it's 2 years. Employers have got to get agreements, and then agreements go for 4 years or until they're negotiated. So there's some agreements. Employers sometimes don't want to renegotiate agreements. For example, there's heaps of zombie agreements from work choices still out there 13 years later. So you could lock in low wages now that could stay in place for at least 4 years into the future, and whether a business is recovered there's no way to go back to what you had before.
The minister says that this is all designed for, you know, a dive company on the Great Barrier Reef, those affected so hard by COVID. So that's why it's got to be explicit to talk about COVID. And he says it's only going to be a handful of cases you're talking about here. What do you say in response to that?
I'd say that that's speculation. That's just him saying that's what he would like. It's not what employers may or may not do. And if employers can go and argue that they've been affected by COVID, that's a pretty broad, you know, grounds to be arguing that they can, you know, give people take-home pay cuts.
When it comes to the casual conversion to part-time, the argument that Labor has said is that you could drive a bus through the provisions here, that employers can avoid turning a worker's casual work into part-time or full-time.
Yeah.
But if you make that too onerous, isn't the risk that the employer just says, sorry, see you later?
Yeah, well, in the case of this, we just believe if people are working regular hours, they're not actually casual in the first place and should be given the rights that, you know, permanent workers have, like sick leave and annual leave. And the problem with this law is that, yes, people have a right to convert after 12 months, but if an employer says no, there's nothing the worker can do about it. And simply what we want is for workers to be able to go to the independent umpire and have the independent umpire decide, yes, it's reasonable that you be converted. Yes, there is an ongoing job. Yes, you are working regular hours. If you don't have that test, casual workers are in such a weak bargaining position. We just aren't improving rights for them.
Because the other challenge is if you've had a worker for 12 months and if you've got 6 months regular pattern of work, which is basically the threshold, once a worker gets to 5 months, a business could just say, look, see you, get the next casual worker if they want that flexibility. That's the problem, isn't it?
It is, and it goes to the other problem with this part of their proposal is that they want to allow employers to label people as casual even if they're not. So on the day you're employed, an employer can choose, OK, we're going to call you a casual, you're not going to get annual leave or sick leave. Yes, we'll pay you a casual loading, but you lose all of those rights. So even if they know it's a permanent job, regular hours, you lose those rights. So you've got to fix it at the beginning. If it's a permanent job, you should get permanent rights. And if you end up working regular hours, give people a proper right to convert.
And just to finish where we were a bit earlier on that better off overall, I guess it's relevant to the casual test as well, but the minister made the point that it's the Fair Work Commission that will decide what's reasonable in this context and what's spurious.
Yep.
Is it fair that he says, look, in terms of a reasonable proposition from a business to say, look, I can't give you part-time work for this reason, reasonable grounds are the words that the bill uses. He says it's the Fair Work Commission that will essentially make that judgment. Shouldn't it be the independent arbiter that decides on both those?
So every umpire makes decisions according to the rules of the game. And essentially what the government's doing is changing the rules of the game and said that you can only, instead of making a decision based on exceptional circumstances, now you've got all of these grounds to allow cuts to take-home pay. And so that's a problem. It won't be the umpire's fault, it will be the rules of the game that are at fault if people get their wages cut.
Sally McManus, thanks, appreciate it.
No worries, see ya.